Okay.
Yang tu berdua.
Okay. Boleh start?
Okay.
Rosaklah.
A very good evening to the panelists and everyone who attended today's forum. I'm Harshwaran and I'll be the moderator for today. Right now, we are having 6 panelists who will be discussing the topic of pure economic loss today. So let me introduce them to you. As the first panelist, we have Miss Sophia and continue with Mr. Azri, Miss Via, Mr. Aiman, Miss Zara, and Mr. Hafizi. I also would like to welcome the panelists who will be involved in the Q&A session later, namely Mr. Farhan, Miss Farah Hanisa, Miss Sarifa, and Miss Kairina for attending today's forum. I hope today is going to be a day full of mind-blowing facts and interesting discussion. What are we waiting for? Without further ado, let's dive into the topic. Today, we will start our forum by discussing the development of pure economic loss. Before passing the floor to the panelists, let me explain to you what is pure economic loss. Pure economic loss refers to the financial loss suffered by the claimant which does not flow from any damage to his own person or property. Rather, the loss is caused through a web of economic relationship in which the claimant is involved. In the development of pure economic loss, 2 parts will be discussed, which are the Negligence Misstatement and Negligence Act. So as the first panelist for today, Ms. Sophia Adrina will present an explanation on negligence misstatement. So without further ado, the floor is yours, Ms. Sophia.
Okay, thank you to our Mr. Moderator. So now let me begin with distinguishing what negligent misstatement actually means, since people are always confused between the negligent misstatement and also negligent misrepresentations. So, an action for negligent misstatements arises where party A has carelessly made a statement to party B where the relationship between the parties is such that party owes a duty of care. A negligent misstatement claim is brought to common law in tort. Generally, on the other hand, the negligent misrepresentation is an action of any form of misrepresentation in between the contract parties, whereas the negligent misstatement may be invoked whether or not it is a contractual relationship exists. So let's take a look of this one case, which is Hadley-Byrne and Heller. So in this case, the court has explained the establishment of negligent misstatement in pure economic loss. Through this case, we can extract 3 conditions that must be fulfilled in order to allow the damage for pure economic loss. Beforehand, the parties must have special relationship that can determine if the party believes that and rely on that defendant's information or advice. And defendants or should know that the plaintiff believes and rely on his information, and it is reasonable for the plaintiff to rely on that defendant's advice according to the circumstances. So let's take a look at a case that applied this principle, which is the Hadley principle, as a whole, where a duty of care arises whenever a party rely on the information from another and the other person giving the information know and ought to know that the inquirer is relying on him and believe with what he said. In this case of Chin Sin Motorworks, Sdn Bhd and another, and Arosa Development, Sdn Bhd and another, the court held that defendant is liable toward the plaintiff as the defendant ought to know that the plaintiff relies on his certificates. So the first factor to consider negligent misstatement is the special relationship, which we also known as business relationship. This is demonstrated in the case of ASO Petroleum Co. Ltd. and Mardin. Despite the fact that defendants were not in the business of giving advice, the court considered that they were experienced and had special expert knowledge in estimating the contents of petrol at the petrol stations as opposed to the plaintiff who did not and a duty of care was imposed to the defendants. House of Lords determined that ESO company still owed a duty of care because the advice given was part of their professionals and business practices. So the next element is the assumptions of responsibility, and this can be seen in the case of Deans and Alleynes and Watts. Mr. Deans made it absolutely clear that he would not be involved in his own solicitor in the matter, and the borrower solicitor never recommended that Mr. Deans seek independent legal advice. The solicitor's legal advice was completely incorrect because the solicitor was aware that he was being relied on and to ensure adequate security for a loan. As a result, the court determined that the solicitor assumed responsibility for himself of continuing an ad without recommending that Mr. Dean seek independent legal advice. So the court determined that the solicitor actually owed the duty of care. So the last element is the reliance. The reliance mean and can be seen in the case of Caparo Industry PLC and Stickman. This is a very famous case. It is the case of where principle of law derived from this case, and the auditor of a public company's accounts owes no duty of care to a member of a public at large or even an individual. Three criteria for the impositions of a duty of care, which is possibility of damage, proximity of relationship, and also the reasonableness or otherwise of imposing duty. There will not be a relationship of proximity if the maker of the statement has no reason to anticipate in his statement might be relied on by strangers for any one of a variety of different purposes. A relationship of proximity can exist if the maker of the statement knows that his statement will be communicated to the plaintiff, will be used to the plaintiff, whether as a specific individual or as a member of identifiable class. So proximity is establishment if the statement is made and a connection to a particular transaction, and the identifiable plaintiff is very likely to rely on that statement for the purpose of deciding whether to enter into the transactions. Therefore, if all the three elements are achieved, then a duty of care can be claimed. To you again, Mr. Moderator. Thank you.
Thank you so much, Ms. Sophia Adrina, for the fruitful discussion on the negligent misstatement. And now, Mr. Asri will explain to us about the Negligence Act. The floor is yours, Mr. Asri.
Thank you, Mr. Harshwaran. So, there are differences between negligence misstatement and negligence act. Just now, Sophia already explained about the negligence misstatement. So, I would like to elaborate more about the negligence act. Negligence act happen when the defendant is negligent in their duty of care towards the property that loses its value. Originally in England, economic loss caused by negligence act could not be claimed under tort. In the case of Murphy against Brentwood District Council, the court held that the defendant counsel owed no duty of care to the plaintiff on the ground that the right to recover for pure economic loss is not flowing from the physical injury or damage to the property. It means that if the person is not injured caused by the defect of property, the person cannot claim on the grounds of pure economic loss. In Malaysia, we also follow the principle brought in the case of Murphy, whereby we can found in the case of Government of Malaysia against Chia Fong Chiu and others. In this case, Wan Muhammad Justice says that the loss suffered by the plaintiff is a pure economic loss, and the third defendant cannot be liable under tort for the loss suffered by the plaintiff. In this case, because no one was injured or no property belonged to the others was damaged as a result of their third defendant actions or misconduct. He also stated that the decision made by the House of Lords in the case of Murphy is very reasonable, affordable, and should be accepted up to any time. For 35 years, Malaysia followed this Murphy principle, whereby claim for negligence act cannot be allowed in pure economic loss. However, in not so recent years, the conflict was emerged in determining whether the pure economic loss is recoverable when it is caused by negligence act. We can found in the case of Lim Tek Kong against Dr. Abdul Hamid, Abdul Rashid, and another. So, in this case, the learned judge said that it was within his right to award damage on pure economy loss. He also said that we have been too long in the shadow of House of Lords decision of Murphy case. He also added that it is time for us to move out of the shadows and move along with other Commonwealth countries where damages could be awarded for pure economic loss. As a result of this ruling, Malaysia has changed its position from being unable to claim for pure economic loss under negligence statute to be able to claim for pure economic loss. However, the problem is not done yet. The judge has difficulty on determining whether it is just and reasonable to impose a liability to the developer in the pure economic loss suffered by the plaintiff. So, the dispute is still remaining until today because the court doesn't have any solution for this issue, especially in determining just and reasonable elements in duty of care. So, I think that's all for me. Thank you, moderator.
Really appreciate your knowledge and sharing on the Negligent Act, Mr. Asri. I hope the viewers have understood the development of pure economic loss. Now let's move on to the problematic question for today's topic. Shopee Limited is an e-commerce company that provides an online shopping platform, and they entered into an agreement to deliver their goods with KNT Express, which became Shopee Limited's supported logistic. However, on 13th November 2021, KNT Express have 3 huge lorries filled with goods and parcel skidded in a heavy rain. It is to be known that all the distributing lorries and vans were not serviced due to the increased number of packages due to 11/11 shopping carnival. Therefore, an estimated amount of 20,000 ringgit of goods and parcels were damaged due to the accident. The following week, KNT Express can't perform any deliveries for the next 2 batches of the remaining parcel and had to delay them due to all the distributing lorries and vans being sent to check up and service. This causes Shopee a huge amount of monetary and reputation loss. Therefore, Shopee's board of directors sought to acquire a new logistic company, namely HTL Express. They decided to check the stock prices for HTL Express in the H market and found out that HTL Express has been selling at a good price. By ignoring the printing disclaimer on the bottom of the stock prices, which states that, warning, these figures are subject to correction and should not be used for business acquisition purposes. Shopee made a successful takeover bid. Later on, it emerged that the price listed was misprinted and HTL has been losing value for months. As a result, Shopee had to sell HTL at a significant loss. As an advocate and solicitor representing Shopee Limited, advised on the following possible claims. The first claim is Shopee Limited's claim against KNT Express as negligently failing to send their distributing lorries and vans to a usual service check before delivering the goods. The second claim is Shopee Limited's wishes to sue the H market for negligent misstatement. So to discuss the first issue, let's welcome Miss Via, who will be our third panelist for today.
All right, thank you very much, Mr. Hashwaran. So let me just recap back the issue here. So what happened here is a company called Shopee Ltd, which offers an online shopping platform to consumers, enter into an agreement with KNT Express, which later became Shopee Ltd supported logistic, whose job is to deliver product to Shopee buyers. So however, because of the sudden increase in packages as a result of the sales event, the employees of KNT Express were swamped with extra workload and failed to send their lorries and vans to a standard service check before delivering the item. So as a result of a severe rain, the vehicles carrying goods skidded on their way, so an estimated of 20,000 ringgit Malaysia worth of products and parcel from the lorry were destroyed because of the heavy rain. So following that, in order to get back on track, all KNT Express lorries and vans are sent to the service and checkups, which as a result, KNT Express unable to deliver item for the next 2 batches on time because their delivery timetable has been thrown off. So because of the delay, Shopee Ltd had suffered a significant financial loss as well as a loss in its reputation as a provider of online shopping services. So if you see here, the issue is whether Shopee can sue KNT Express for negligently failing to send their distributing lorries and vans to a usual service check before delivering the goods. So if we go back to what Mr. Asri explained earlier about the development of recoverability of pure economic loss due to negligent act in Malaysia, we can see that the Shapee Ltd, as the plaintiff, can actually claim for the economic loss due to against the defendant. So just like in the case of Lim Tek Kong and Dr. Abdul Hamid Abdul Rashid and another, where the court dismissed the appeal as it was laid down that the pure economic loss is recoverable if it is a foreseeable result of the defendant's breach. And for this case, we can see that due to the fact of the lack of usual service checks in distributing the lorries, it is foreseeable that something unfortunate might have happened, as doing a routine service check is an important job to do, especially in ensuring the parcel to be delivered in a safe and sound manner. So as a result, the defendant, which is the KNT Express, is said to be liable for its carelessness. Thus, under the Malaysian position, Shapee Ltd's claim against KNT Express for negligently failing to send their distributing lorries and vans to a usual service check before delivering the good is highly likely to be a success. Hence, apart from the 20,000 ringgit Malaysia, which is the direct physical damage towards the parcel, Shapee Ltd can also claim back for the loss for the next two batches of the remaining parcel, even though it is a pure economic loss. That's all for me. Going back to you, Mr. Hashwaran.
Thank you so much, Ms. Via, for your view on the possible claims that the Shapee Limited can request in the court from KNT Express. To discuss the second issue in the case of Shapee, let's give a huge round of applause to Mr. Aiman.
Thank you, Mr. Moderator, for passing the floor to me. So moving on, there are examples where the issue of negligence misstatement took place. Based on our problem, to mitigate the loss, the Shapee Limited Board of Directors decided to expand their business interest by investing in a new company named HDL Express. By that, they decided to refer to the stock prices for HDL Express in the H market, which is a business and investment weekly that provides analysis of corporate capital markets and property technology business and management news in Malaysia. They stated that HDL was worth the investment, but included a disclaimer that the information can be subjected to change and correction, therefore should not be used for business purposes. Ignoring the disclaimer, Shapee Limited made a successful takeover bid based on this information. It later emerged that the price listed for HDL Express is in fact a misprint and that the organization has been losing value for months. As a result, Shapee Limited had to sell HDL Express at a significant loss. So, the issue that can be brought upon us now is whether Shapee can sue the H market for negligent misstatement. We have heard that Ms. Sophia and Mr. Asri discussed the development of both negligence in misstatement and act. It can be clearly seen that the question of is there any duty of care owed by the H market towards Shapee can be answered by satisfy the element of special relationship. Firstly, it does not fulfill the first element as Shapee cannot rely on the H even if they trust the H market as advisors. Shapee and the H market have no special relationship as an advisors for Shapee about the stock prices, and as the information is too widely disseminated. Thus, there is no special relationship between Shapee and the H market. Next, Shapee relied on the H market regarding the stock prices, but they ignored the warning. In addition, relying solely on the H stock listing as an indicator of an organization's stock listing is neither foreseeable nor reasonable. In addition, the Financial Times disclaimer means that it cannot be said to have voluntarily assumed the position of advisor, similar to Hadley Burn. Hence, when the H market gave the misleading statement and Shapee trusted them, it was not valid as there is no special relationship between Shapee and the H market, and the H market does not owe the duty of care towards the Shapee. And thirdly, DH Market was a company that was trusted by Shopee about purchases. DH Market acknowledged about the facts and they were trusted by the Shopee, and there will be no source of information that Shopee will trust than them. However, the stock listing by the H market is too wide and general, and the H market also wants about the price of stock listing. So, in conclusion, H market cannot be sued under the negligence misstatement by the Shopee Limited. Thank you.
Thank you, Mr. Aiman, for your insightful sharing. Now we'll be moving on to the issue and criticism for pure economic loss. Therefore, let's have Ms. Zara to discuss the floodgates. Before that, allow me to give a brief introduction about floodgates. The floodgates principle, also known as the floodgates argument, is a legal principle used by the judges to limit or restrict a claimant's right to make a claim for damages, because they are concerned that allowing a claimant to recover in such circumstances will open to metaphorical floodgates to a large number of claims and lawsuits. That's a small introduction from me, and let me pass the floor to Miss Zara. Here you go, Miss.
Okay, thank you, Mr. Moderator. Now I'll be talking about the first issue and criticism for pure economic loss, which is floodgates. So, what are exactly floodgates? As Lord Denning put it, there would be no end of claims. As we all know, in other legal systems, courts and lawyers alike are not impressed with the floodgates argument. But what does exactly the term floodgate refer to? A first meaning might be that the courts will be flooded with claims similar to the one adjudicated. A second meaning is that an individual tortfeasor will be flooded with claims, resulting in financial ruin. The first meaning lacks clear empirical backing and is sometimes dismissed out of hand. The second meaning, in particular, may be deserving of more attention. However, it is important to note that not all situations of pure economic loss are accompanied by the prospect of inundation. There is no such threat in circumstances of transport loss, for example. In other cases, which might be cases of relational loss, negligence statements, and many more, the threat may be real, but this does not mean that allowing claim for these losses in principle would necessarily lead to unbearable financial consequences. Perhaps this is why the above-mentioned admissive jurisdiction appear to have fared so well. While they enable the claims for pure economic loss, they limit the scope of liability in practice by using additional tools like causation, proof of damage, the victim's obligation to reduce losses, and so on. The floodgates argument in relation to duty of care in negligence is that a duty of care should not be imposed because it may generate a large number of similar claims. This could result in an onerous financial burden on the insurance industry responsible for paying damages. It is part of the third limb of the test for duty of care in the case of Caparo against Dickman, that it must be fair, just, and reasonable to impose a duty. The floodgates argument often underpins public policy decisions made by the courts. Certain types of harm types of defendant can give rise to floodgates argument. Example where the court recognized the floodgates argument includes a claim for psychiatric harm and claims against the public body such as the police. For example, in the case of Alcock against Chief Constable of South Yorkshire, where the House of Lords decided that in finding for defendant, held that in cases for purely psychiatric damage caused by negligence, a distinction must be drawn between primary and secondary victims. A primary victim was the one who was present at the event and as a participant, and will be thus owed by a duty of care by defendant. Subject to harm caused being foreseeable, of course, and secondary victim, by contrast, would only succeed if they fell within certain criteria. And that's all from my part. Back to you, Mr. Moderator. Thank you.
Thank you, Ms. Zara, for your in-depth discussion regarding the topic just now. And now let's move on to the second issue and criticism for today, which will be regarding the difficulty to determine future loss. So let's welcome Mr. Hafizi to lead us through a knowledge-filled discussion.
Thank you, Mr. Moderator. So the second issue and criticism that restricts the court decision in allowing pure economic loss is the difficulty to determine future loss. So the profits that the plaintiff ought to make given the defendants were not negligent cannot be determined, as it would impose a greater burden on the defendants. This can be seen in the case of Spartan Steel and Alloys Limited and Martin & Co. Contractors Limited, where the judges distinguish between economic loss consequent upon physical damage to property and pure economic loss. In this case, the plaintiff suffered a variety of losses as a result of this, including lost profits due to the factory's inability to operate during the outage, as well as physical damage to metal that was in the process of being smelted at the time the power was lost due to the defendant's action of digging up a road that severed the factory's power supply. The plaintiff seeks damages for a reduction in the melt's value, loss of profits from the damaged melt, and also profits on melts that could have been processed during the outage. The defendant was held liable for the loss of profit as well as the reduction in value of the first melt, but not for the loss of expected profits, according to the Court of Appeal. In delivering the judgment, Lord Denning stated that imposing liability would merely serve to overwhelm the court with claims for pure economic loss. Moreover, the third type of damage suffered by the plaintiffs was a pure economic loss independent of physical damage and was therefore irrecoverable. This restrictive approach was then adopted in subsequent cases, except Junior Books Limited and Vetchico Limited, where it was decided that a close relationship between the parties was adequate to allow for the recovery of pure economic loss. The defendants were flooring experts who were hired as subcontractors to lay a floor in a factory that the plaintiffs would use. The plaintiffs argued that the floor was defective as a result of the defendants' negligence, and that because they were expert in the field, they were liable for the damage caused by the cracks in the floor. As a result, the plaintiff filed a lawsuit seeking reimbursement for the cost of mending the floor, as well as lost profits and the cost to manufacturer of having the floor restored. The claim was upheld despite the fact that the floor did not pose any immediate hazard to the building's occupants. In reality, this was the first and last time the courts explicitly held a defendant liable for creating pure economic damage as a result of negligent act. Thank you from me.
Thank you so much, Mr. Hafizi, for your insightful and informative discussion about the difficulty to determine future loss. This marks the end of the discussion with the panelists who have presented their parts so well. Before we proceed with the Q&A session, give me a moment to conclude the discussion. In sum, it is clear that the liability for negligent infliction of pure economic damage must be imposed in accordance with a moral standard underlying all negligence cases. And the law must evolve in such a way that this standard is applied consistently and coherently. In most cases, moral or ethical consideration will determine the bounds of accountability, as seen in the instance of the problematic question above. A claim for pure economic loss, on the other hand, is not restricted to damaged building and structures, but is expanded to include all scenarios. The court, on the other hand, remains silent on these comparable possibilities. As an outcome, each case, facts, and circumstances will be assessed to determine if placing a duty of care on the defendant is fair, just, and reasonable. And now, moving on to the last part of the forum, which is giving the opportunity the audience to ask us questions. We can conclude that each panelist has their own view towards the issue, and most of them voice their respective opinion about the problems in pure economic loss issue. We have come to the end of a wonderful show today. Before we bid each another a farewell, we are now open for a Q&A session. For everyone's information, we have different panelists starting from Mr. Farhan, Ms. Farha, Ms. Farah Anisa, Ms. Sharifah, and Ms. Kairina to answer all the questions that will be put forward by the audience. Without further ado, let's proceed with the first question. So the first question from our viewers is, I want to ask if the plaintiff relied upon the advice of the defendant and defendant gave bad advice, can issue sue for the defendant for the pure economic loss in all situations. So the first panelist, you can proceed.
Can I answer, Mr. Moderator?
Yes, proceed, Mr. Farhan.
Okay. So it actually depends. If the plaintiff has no knowledge in the particular field that he's involved in making a decision and rely on the defendant's advice, then the defendant will be held liable. One of its examples is a relationship between a client with his solicitor. So if we look in the case of Maelstrom Resources against Sheeran Delamo and Co., the defendants, which is the plaintiff's solicitor, failed to properly inform the plaintiff of the foreseeable prolonged process of litigation involved in the application of patent for the plaintiff's device. The plaintiff lost a lot of money in the span of 2 years and was no longer in a financial position to exploit his invention by that time, even though the decision was in the plaintiff's favor. The defendants were held liable for their failure to advise the plaintiff with respect to the legal impediment. But if we look in the case of James McNaughton Papers Group Limited against Hicks Anderson and Co., the approach is a little bit different, as in this case, the plaintiffs were informed by the defendants that a company called MK was breaking even, which means that the company does not make a profit and at the same time does not suffer a loss. On this basis, a successful but consequently financial unprofitable takeover bid was made by the plaintiff. It was held that since the accounts were prepared for the MK company and not the plaintiffs, it was unreasonable for the plaintiffs to rely on the defendant's statement without seeking further independent inquiries. So from this case, we can see that it is unreasonable for one party to rely on the advice of the other party without any prior investigation being made by the party seeking to rely on the advice, as he is in a position to protect his own financial interests. I hope that answers the question.
Yeah, I hope that too, Mr. Farhan. So thank you so much, Mr. Farhan, for the thorough discussion on this, for the question arised by the viewer. So let's move on to the second question arised by the viewer also. But what if the plaintiff rely upon the advice of the defendant, but the defendant never claimed he is an expert or even realized that the plaintiff would rely on his advice? Can the plaintiff sue the defendant for pure economic loss in all situations? Who would like to answer this question?
Okay, I would like to answer this question. So again, before we discuss this issue, we need to recap the meaning of negligence misstatement itself, where it said that a person may held liable for a statement made where the reasonable reliance on statement give a rise to financial loss. In addition, we need to be aware about the factors on determining on this issue, where it can be said that there's a duty of care. First factor we need to know that is plaintiff believe and relies on the defendant information or advice. Secondly, we need to see whether defendant knows or ought reasonably to know that the plaintiff will believe and rely on his information. And last but not least, it is reasonable in circumstances for the plaintiff to believe or rely upon the defendant information or advice, knowing that the defendant itself have a special knowledge on that kind of area. So pertaining to the question, it can be said that the defendant is not held liable. It doesn't. If pertaining to the question whether plaintiff would rely on the advice of the defendant, but the defendant never claimed he is an expert or even realized that the plaintiff would rely on his advice. So my answer, it will say that from all the factors, it can be said that defendant is not held liable because it doesn't check all the factors which defendant did not know. The plaintiff will rely on his advice, and defendant never claimed he is knowledgeable on the area, which can be seen on the case Mutual Life Citizen Assurance Co. Ltd. and IBAT. But another case is quite similar, which is Chowdhury and Prabhakar, where the judgment is different. Where in this case, the defendant himself there has no knowledge, special knowledge of the area, but he claimed himself as an expert in the area, which makes his friend or the plaintiff had relied on his advice, which proved detrimental. That's all for me.
Thank you, Ms. Farah, for your answer for the question raised. Now, let's move on to the third question. In your opinion, can someone claim for damages, or can this matter be brought to court although there is no contractual relationship? For this question, may I invite Ms. Sarifa to answer?
Yes, of course. Thank you, Mr. Moderator. Well, if we look back in the early stage of the development of pure academic laws, this matter can only be claimed if the party had a contractual relationships. These relationships exist in relationships between buyers and sellers, housing developers and home buyers, and so on. For example, in the case of Teh Kem On and Tia and Wu Developments in Jambu Berhad, the plaintiff had purchased a house from the defendant in 1994. However, there are several defects that occur, such as leaks in the bathrooms, cracks in the wall of the house, and also uneven ground. The defendant were notified by the plaintiff about the defects, and they repaired the house. But another problem arose after that, when the back door could not be locked and the house was slightly sunk. The plaintiff moved out of the house in 1985, and then the defendant agreed to repair the house after that. However, there is no agreement between the plaintiff and the defendant as to the manner in which repair should be carried out. So the plaintiff brought a claim of negligence against the defendants, architect and engineer. However, the court found that these claims were pure economic loss claims, and then the court held that the architect and engineer was not liable to the owner of the building for pure economic loss, as there is no contract between these two parties. That's all from me. Back to you, Mr. Moderator.
Thank you, Ms. Sarifa, for your insightful discussion on the question raised. And now let's move on to the last question for today's forum. So the question is, earlier, Sophia mentioned in the matter of the development of negligent misstatement, but I would like to touch a little bit on the minority decision to establish the element of special relationship in the case of mutual life assurance. So do you mind going deeper into the decision in that case? So who would like to answer this question from the panelists?
I would like to answer this question.
Thank you, Ms. Karina.
Okay. As everyone knows, the Hadley-Burn principle was followed in the case of Mutual Life and Citizens Assurance Co. Ltd. and IBAT, where the majority decision held that duty of care would only arise if the defendant is in the business of giving advice in a particular field. It must be apparent and obvious that the plaintiff's circumstances necessitated that the defendant's advice and opinion. As a result, whether or not it is reasonable for the plaintiff to rely on the defendant's guidance depends on the facts and circumstances of each instance. The minority opinion stated that when a person seeks advice from another person while the other person is performing his business, and the person seeking the advice makes it clear that he will rely on that advice, a duty of care may nevertheless exist. If the advice is given without conditions, the party giving it bears a duty of care to act properly in those circumstances. But we shall look at the minority opinion in that case, where even though the defendants were not in the business of giving advice, the court looked into consideration that they were experienced and held special and expert knowledge in that matter. However, the application of that minority opinion affects a liberal interpretation of what is a special relationship. Thank you.
Thank you, Ms. Sarifa. So this ends the end of the discussion. So thank you so much to the panelists for answering the questions. that have been put forward by the viewers with such great information. So we have reached to the end of the forum, as I mentioned earlier. So I hope to see all of you the next time. Thank you so much.